respected Shri R. Venkatramani, the Attorney General for India, Shri Lalit Bhasin, the distinguished guests, co-speakers, ladies and gentlemen. A very good morning to all of you. When the ET World came to invite me to speak on intellectual property and how India should look at intellectual property in the years to come, I was thinking about whether this is time to showcase what India has already done or what India needs to do. On an everyday basis, we deal with intellectual property litigations in India. And there is no doubt that we have walked several miles, but as is always said, we have several miles to walk. Technology is posing the biggest challenge to us in the field of intellectual property, and India is now no longer a quiet spectator. It's time for India to take its leadership role in intellectual property, and that is what I will be speaking about today. You know, when we go back to our scriptures, India always believed in sharing knowledge, and that knowledge had to be disseminated for the interest of the public and for society at large. Information was seen as an empowerment instrument which was to be enjoyed together by society. Knowledge was transmitted primarily through oral recitation initially, and thereafter even through the scriptures. The entire concept of knowledge did not have an individual conception, but as a pool for the society to use and disseminate generations to generations. However, in the 19th and the 20th century, India underwent, both in the colonial rule and post-independence, a complete change in the manner of thinking in intellectual property. And this is possibly because of the British rule in India and the laws which were introduced in 1800s, both in copyrights and in trademarks. So if you see the journey of Indian copyright law, it was first introduced in 1814. It had the 1957 Act, which came about post-independence, had provided sufficient civil and criminal remedies with exceptional standards for fair use, such as educational use, legal use, social and cultural use, etc. The term of copyright was also enhanced from 50 years, death of author plus 50 years, thereafter to 60 years, which is called the Tagore Amendment. We protect under the 1994 Act computer programs, literary works. Proper systems were put in for copyright societies, though there is definitely a need to reform in that area. In 2012, technology was taken into consideration, digital rights management, statutory licensing, and all these provisions were incorporated into the Act, including a special set of provisions for safeguarding of authors' rights. Let's look at patent law, how it changed. 1856 was the first act, 1911 was the second act, both were during the British regime. The Rajagopal Iyengar committee report came in along with the Bakshi Tekshan committee report, which completely overhauled Indian patent law. 1970, we got our first act, which did a wonderful job in terms of providing for product patents and process patents in the fields of pharmaceuticals and chemicals. Thereafter, however, India had to get into the TRIPS regime, which provided pan-product service patents to all fields of technology. India has always, in patents, been looking at the balance between innovation and protecting public interest. This is also clear from the position that India took in the pandemic. Let's look at trademark law. Trademarks, India is an absolute leader. It is in fact far ahead of its global counterparts. Almost all well-known marks are protected in India irrespective of use, which is an absolutely exceptional thing compared to other jurisdictions. We have broadened the scope of infringement of trademarks to even expand into unrelated goods and services, which is unusual. There are proper electronic facilities which are now available. I recall the time when, in order to be able to download or obtain data relating to a trademark, we would have to send a representative to the trademark office at least 1 week continuously every day. We would never be able to access the data. From there, we've come a very, very long way. Almost every document relating to trademark registrations, patent registrations is now available online. The database is absolutely modern. This infrastructure is again being overhauled, I'm told, recently. And today, almost all attorneys and clients are able to access data relating to their trademarks and patents online, sitting in their offices or homes. We've also expanded the definition of trademarks to include shapes, sounds, combination of colors, etc. So insofar as trademarks is concerned, I can confidently say that India is a world leader on trademark jurisprudence. Let's look at something more closer to home, geographical indications. The TRIPS agreement provides for geographical indications in respect of wines and spirits, but India has enacted the Geographical Indications Act, which is, I think, our strength, because we have the maximum number of communities which work in the area of geographical indications, whether it is the Kanjivaram sari, whether it's the Channapatna dolls, whether it's the Kolhapuri chappals, whether it's the Darjeeling tea. Almost all the geographical indications in India, at least 300 to 400 of them have been registered in India. So what do we need to do for them? That will be in the next slides. Traditional knowledge. Again, India has been a leader. There was a time around the 2000s when certain patent applications which were filed in the US and EU for turmeric-related formulations and neem-related formulations were realized within India. So I remember at that time, the CSIR and other bodies worked together very hard to show how these are traditional knowledge pools which are existing in India. Use of turmeric or neem is no longer, kind of patentable even in any form. So at that time, while India opposed the grant of patents to these formulations in foreign patent offices, India did something exceptionally significant, and that is the creation of the Traditional Knowledge Digital Library. That's the TKDL. And this TKDL library is one of the most rich databases of entire traditional knowledge which is available from ancient texts, scriptures, everywhere, across all religions, in fact. This traditional knowledge library is now shared with patent offices across the world. So in order to ensure that whenever searches are conducted for patents involving traditional knowledge or bio-related plants, etc., the library is available for those patent offices, including the WIPO, the EU database, the US Patent Office. Everyone has access to these traditional knowledge databases. So we have also enacted a provision under the Indian law called Section 2P, which says that traditional knowledge-based patents cannot be granted in India. There is also a move to protect traditional knowledge through a bill. The bill was tabled before Parliament, but it's pending consultation. So now, what are the key ideas where we are already engaging in IP law, and currently what are all happening in the litigation sphere? If you look at patent law, we are looking at novelty and inventive step in different areas of technology. There is a lot of debate going on about whether computer programs or technical impact of computer programs needs to be permitted to be patented. How do we balance between granting patents for medicines and access to medicines in terms of the Doha Agreement? How is the compulsory licensing system to be used in a more effective manner? There are what are called standard essential patents, which determine what the global standards should be across products and services. Mainly in the area of telecommunication, we are seeing a lot of litigation in India. And India is again a leader in ACP litigation. In copyright law, we are facing a lot of challenges in courts in respect of intermediaries. For example, this judgment of Neetu Singh versus Telegram deals with a case where there was a teacher who had created copyrighted works in the form of course material. There were Telegram channels which were created where her course material was being disseminated by people to hundreds of students. And when she asked Telegram to disclose who these people were, who were involving themselves in this infringing activity, Telegram took a position that since their servers are located in Singapore, they would not be willing to disclose the details of the persons who run these channels. And believe you me, it was on the ground of privacy that the disclosure was being blocked. So the court looked at the position of law in Singapore, position of law in India. Respecting all these positions, Telegram was directed to disclose the people, because at the end of the day, the teacher is entitled to damages on the infringement which has happened. And we don't know if, most probably they could be Indian people, and so she can't be deprived of right to claim damages. So it's a very positive development that Telegram acceded to the judgment, agreed to disclose the data, and agreed not to challenge. So therefore, there is increasing technological issues which are being faced due to location of servers in foreign countries, accessing of data, stopping of piracy, stopping of illegal domain names, and implementing Indian orders in other courts. And I'm sure other courts are facing the same issue. So there is a need to kind of evolve some kind of an international consensus on how to deal with intellectual property on the internet. And these litigations are before our courts, and we are dealing with them on a day-to-day basis. Again, in trademark law, as I said, India recognizes trans-border reputation and has diluted the requirement of use to a very great extent. And I can say from personal experience that, Indian clients and Indian industries do find challenges in registering their marks abroad where they are not using them, actually, physically. Whereas foreign marks are registered easily in India, even without use. There is, in all this intellectual property, I keep saying one thing, that there is this feeling that intellectual property is for the rich and the elite and the sophisticated people. But I always say that as the court, as a judge sitting in the court, there is a plaintiff and there is a defendant, but what the court looks at always is the third person who is not in the court, and that is the consumer. Whether it is a medicinal product, whether it's a food product, whether it's a counterfeit, any kind of product where there's a passing off or a violation of a trademark or a brand, it is the consumer who is cheated, apart from the plaintiff itself. So I say that intellectual property protection has a public interest in it and has a consumer interest in it, which the court always takes into consideration before deciding a particular matter. Recently, there was a case in the Delhi High Court where one judge took such a pragmatic view. The case was that the defendant said that the plaintiff is guilty of concealment of material facts, but the product brand was being misused. So the court said maybe the plaintiff has done something wrong, but I also have to look at the consumer. And in fact granted the injunction. So these are all different dimensions in intellectual property. There is domain name squatting which is happening. There are 40 to 50 litigations which the court is currently dealing with, where people have registered domain names, for example, Tata dealership, Dabur franchisee, of well-known marks. They collect money on the ground of either giving employment or opening franchisees or dealerships. And most of these domain names are registered in foreign countries by foreign individuals, but there is a whole banking system which is being used, and crores of rupees have been collected from the Indian consumers in these suits, and more than 12 arrests have been made in these matters. So increasingly courts are finding technological challenges in implementing intellectual property. Now, what is going forward, what is it that's going to happen, and how is intellectual property going to change? There is artificial intelligence. These images have been created by my group of LRs using artificial intelligence. The question is, in the area of artificial intelligence, AI can create new works. It can create copyrighted works, it can create new technology, it can create all kinds of content. But who owns the right in all this? There is no clarity on this as yet. Can AI created works enjoy intellectual property? There is a case in India where the AI was shown as an inventor in a patent application, and the same was rejected by 3 countries. But Australia took an opposite position. Australia said, yes, why not? We can give a patent to an AI. Why not? Now, if AI can be given a patent, who would own it? Is it the creator of the AI? Is it the person who's feeding the data to the AI? Or is it the person who's running the AI and giving it ideas? So these are issues which none of us can answer as of today. Let's look at blockchain. There is a big issue in how to identify who owns a particular IP in the chain. There was a recent case in the Delhi High Court related to blockchain innovation. So these are real cases coming before courts. And of course, as I said, the internet, which is making it so challenging to enforce IP. Do we need TRIPS 2.0? Or do we need a new multilateral agreement or a policy which can be framed internationally to deal with these challenges so that there is uniformity in the manner in which countries deal with them? As far as India is concerned, I feel that the time has come for India to look at intellectual property not in a defensive or in a kind of a hesitant manner, but to actually redefine intellectual property, redefine it in a manner so as to encompass all the new innovations that are taking place, and to make way to monetize intellectual property for India. The kind of intellectual property that India is actually sitting on, for example, in the area of copyright, India is the largest creator of creative works in the world. But we don't make the kind of money that Hollywood makes. Why? Because we are not able to monetize them. Most of the Indian news channels or movies or music are pirated across the world. India doesn't get a single penny of royalty for any of those. These are the areas where India needs to learn how to commercialize, how to monetize, and how to make sure that the intellectual property which is created in India can make economic and monetary benefit to its communities. In my own view, there is a huge development that has happened in the last 4 or 5 years in the form of, for example, the India Unified Payment Interface, Bheem, RuPay, CoWIN. I mean, I'm sure any of us who used CoWIN will be able to say that it's one of the most efficient digital platforms that may have been created, even including Aadhaar, for example. All of these platforms are the biggest innovations that India has made, but there is no intellectual property in it. Why so? Why are we not able to do it? The data which is collected by these platforms is, again, a monetary minefield. This data, for example, which is used on CoWIN, can be collected to, change the landscape of how medical treatment need to be given to different segments of patients in the country. During COVID-19, the amount of data that's been collected about Indian population, Indian, the kind of issues that the medical issues that Indians face, it is again a minefield for research and development. Why is this data not being monetized? The innovation which is being done both in the rural and in the urban areas, including by SMEs, there needs to be a big fillip on this area, on this front as well. Trade secrets. We don't have a statute, and maybe it is high time to look at trade secrets as a statute, because at the moment we only try and protect it under the contract law, which may not be sufficient. Please look at what's happening in other countries. Japan, US, and Israel. They all have come out with some kind of policy decisions and guidelines to permit using data sets for training AI models. And therefore, these are anti-copyright. These are not pro-copyright, but anti-copyright. We need to sit down and see as to where India needs to go in this area. So, my time is getting up, so I'll conclude quickly. The way forward would be, in my view, it is to focus on India's strengths. There is large amount of data sets. We need to monetize them. Clinical trials, we've done very well in the last 2 to 3 years. Large number of clinical trials are happening in India. more boost needs to be given in the health sector to clinical trials. Innovation in technologies, we should enable commercialization, even if there needs to be some kind of a centralized platform for geographical indications. All these products have a big market internationally. Though there are, in some pockets, some development is being made for commercialization, it is not totally kind of integrated. It needs to be integrated into some kind of a centralized database. Is there a new relook required for copyright and patent laws in view of emerging technologies? In accounting and taxation, all enterprises should be permitted to value their intangible assets. They should be permitted, for example, I recall one startup case where for that particular startup, one patent is all they owned and they got the funding on the basis of that one patent. Just imagine all the companies, if they're able to value their intangible assets and reflect them in their balance sheet and use them for the purposes of, raising finance, raising credit, how that would really help for them to increase their investment in research and development. We should permit that. There's one thing that I would definitely like to mention here, that in the area of science, research and development, we have a large amount of untapped potential in the form of women who are well qualified scientifically graduates. Do you know that in India, more than half of the postgraduates in STEM subjects are women? However, when it comes to research, they own only 3% of the patents. Why is that? So, if you look at 100 people who've graduated with an MSc or a BTech or an MTech, half of them are women. Most of them are not used in the research and development field. In the remaining half, there is a good migration of the large number of scientists who go. So, on the basis of merely 30 or 40% of the graduates is what Indian economy it is today. Imagine using the entire untapped potential of women who are graduates, who are postgraduates, who have large amount of scientific potential. I think that is where we need to kind of make it possible for women to contribute in research and development. The National Research Foundation, which was announced yesterday with a huge budget, is maybe one of the ways to go to make sure that there's more research in higher educational institutions. The abolition of the IPAB, though initially met with a lot of resistance by the IP community, it has turned out well. The creation of the IP division in the Delhi High Court and recently in the Madras High Court is showing progress. I keep calling our IP division as a specialized court without specialized judges. But the court is functioning, the disposal rates have increased tremendously, and the court is doing very well. This needs to be replicated as recommended by the parliamentary committee in almost all high courts in the country, so that IP is not just Delhi-centric or Bombay-centric or Calcutta or Madras-centric. It should move to other high courts as well. IPR, according to me, is for the betterment of society. India has found the right balance in, ensuring that IP works for the society, and therefore, in my view, the time has come for India to be the future IPR leader and not a mere implementer of globally, agreed terms. In fact, we should be prescribing the terms now. Thank you very much.